Counsel, you're suggesting who is your next witness
Leandra Phillips,
and what she had testified to?
the identity of the deceased, Christopher Thomas.
All right, and
May I ask the relationship of Ms. Phillips?
The mother.
We would object on the grounds of that case.
all right, and Counsel, the way I read the case earlier, it basically said it's not the preferred method because they're concerned, and I asked you whether you spoke to the witness and concerned about her getting emotional on the stand. You said you did, correct?
Yes, sir. We talked about that, and then what I can also do to alleviate that is have them authenticate the USB and the drive, but not publish it until after they are off the stand.
And counsel also indicated he was objecting not so much that he was concerned about her being emotional, just the effect it would have on the jury, is the way I understood. Is that correct, counsel?
That's correct, sir.
And so he was saying that there's other witnesses available who can testify to basically the same thing. And my recollection at sidebars, you said that you didn't have other, and you put in the words, credible witnesses that would be able to identify the decedent. Is that correct?
That are non-law enforcement. That is correct.
And that we would respectfully suggest that suggests that these two decedents knew nobody in this world except their family, which is hard to believe, and that in itself is not credible contention. The state's been investigating this case for 4 years. This trial is anticipated to last beyond the next few weeks, and we strenuously object to this process being engaged in dereliction or in violation of the case law. Not a case, many cases.
Again, I have to pull a case up that I found out of Supreme Court. I believe it was Rodriguez is the case, State v. Rodriguez. I could be wrong, but that's my recollection. But that also indicated, as a general rule, it didn't say it can never happen, and it also talked about whether there are other credible witnesses that could basically testify to those issues that the alleged victim is dead, one of the elements of proof the state has. So I'll find that case again and just see exactly what it says, but that was my recollection. The second thing, though, is I thought this was resolved by, you made a suggestion that you're going to stipulate to it, and so we tabled it. That was the understanding that I asked about having the stipulation, when would that be, and when would that happen, and you indicated that after, I guess, the luncheon recess or something, that you had further conversation, and you were not inclined to enter the stipulation after discussing that with your client.
Yes, Your Honor. Yes, that's correct. And here's the thing: I would think that if that the state would be for there to be a complete record, to be able to put on the record a good faith effort that it made to identify anybody on this planet that knows these two decedents other than their family, saying we spoke to two people and they declined or couldn't, wouldn't cut it. So I think the record would have to contain an itemization of their efforts before the court draws a conclusion that the only witnesses who would suffice are the ones that the case law discourages.
I'm looking at the case now, so.
To the citation of the other case, Your Honor, I don't need to read it into record. I'm sure the court has.
The one I'm reading is Rodriguez v. State, and it's cited at 919 Southern 2nd, 1252, and it's really just a short paragraph, very generic, but it basically says that's not the preferred method to identify, as long as there's non-related credible witnesses are available to testify as to the identity of the deceased.
Right. And I believe the seminal case is Weltry v. State 402 Southern 2nd, 1159 from 1981.
402?
Southern 2nd, 1159.
I apologize. I gotta get out of this.
That's a seminal case, Your Honor, and I would just respect
402?
Southern 2nd, 1159, Florida, 1981. And I would just, as the gatekeeper, Your Honor, if the rule is that a member of a victim's family should not identify a victim at trial where non-related credible witnesses are available to make such identification, I would assume the predicate for making such a determination would be identifying that non-related credible witnesses are indeed unavailable, which would require the state to document its efforts in obtaining them.
I believe that was already put on the record at sidebar as to those efforts that were made.
If that's what they wish to rest on, Your Honor, we would contend that it's insufficient. It was a declarative statement with no detail.
So in this case, though, that you're citing, it basically says it's clear from the record that the brother's identification testimony was not of such a nature as to evoke the sympathy of the jury or to prejudice the defendant. Nor can we say that the brother's testimony was not necessary to establish the identity of the deceased beyond a reasonable doubt. Here, the neutral witness referred to by Welty were a fingerprint technician who testified that the prints from the victim's right hand matched the prints of Burkhalter on file with the Federal Bureau of Investigation. As a result, in April 1976, DWI arrested Burkhalter and a former member of the Castleberry Police Department who had arrested Burkhalter in '76 for DWI and who identified Burkhalter from a 1976 mugshot taken at the time of the DWI arrest. Even though Welty was willing to stipulate to the identity of the victim, this did not prevent the state from presenting additional relevant evidence to prove identity beyond a reasonable doubt. We find the trial court did not reversibly err in permitting this testimony.
It's not precluded in instances where it's necessary and they can establish a necessary predicate. They can't do so. And we're also inviting error by taking the risk that unfolds when the state has ample resources and time to go and find a witness that's suitable and comports with proper protocol.
Anything else?
No, yeah.
Well, this is my thought. I wasn't, as I indicated, I wasn't aware of the rule previously. I've tried many homicide cases, and 90% of the time it's stipulated to, although I have had people testify as to the identity. I'm not certain whether they're family members or not, so I don't want to take that lead. I wasn't familiar with the case, but the case seems clear. It's not the preferred method. Don't do it. They're objecting to it. So at this juncture, I haven't heard exactly what efforts were made. I don't know if there are any other witnesses, so we're just going to table it for now. I want to hear whether or not you can have another witness testify as to a non-related credible witness testify as to the identity of the two victims, Mr. Williams and Mr. Thomas. Right?
Yes, Your Honor.
All right, so do you have any other witnesses today?
No, Your Honor.
All right, so we're just going to adjourn now. How does this issue with the medical examiner, how's that going to play out?
We will address scheduling on that, moving around witnesses right now for tomorrow. So we will be plenty of witnesses for tomorrow. I'm still juggling people around to fill in some of those gaps.
Anything else to discuss, counsel?
No, Your Honor.
Nothing, sir.
All right, just bring the jury in, and I'm going to tell them we're done for the day.